दिगंबर कामत आनी चर्चिल आलेमावाक मेळिल्ली थाकाय तात्पुरती. तांचे आड कारवाय फुडें व्हरपाक परत मंजुरी घेतले अशें ईडीचे आदोगादान स्पश्ट केलां. ह्या निकालाचो केशीच्या मेरिटाचेर कांयच परिणाम जावचो ना अशें ते म्हणटात. चर्चिल मात सांगता आपूण इनोसंट.
एक केस लुईस बाजार म्हणून सोंपलेलो पारेकारान म्हाका इनवॉल्व केलो. लुईस बाजाराक कोण कितें केलां तो भोगतलो आनी भोगिला सगळें अनुभव. लुईस बाजार एक केस भायर पडून हांव हॅपी ना, हांवें तें काम केलें ना. यू अंडरस्टँड? सो हांव लुईस बाजार एक केस भायर पडून हांव हॅपी ना. लुईस बाजाराक काम हांवें केलें ना. लुईस बाजाराक हांव केन्ना हितून पडना. हांव 1969 तारोड जालां. 80 पासून म्हजी एक पुलिसी केस आसा चोय. 1949 टू 80 पासून म्हजी केस आसा दाखय म्हाका. जेन्ना पॉलिटिशियना भितर सरलो 89 ते 90 खूब केश्यो. आनी हांव जाणा पॉलिटिक्सा भितर सरलो तुवें जेल वयच पडा, तुवें जेनेरास पडा, तुका सगलें आहा. आनी त्या तरेक तूं जर चिंतील जाल्यार तुवें पॉलिटिक्सान वचूंक जायना.
Now, charges and cognizance were challenged in this case on merits, and it has been pending before High Court from 2021. Come 2025, there was a judgment called Bibhu Prasad, wherein Supreme Court has stated that the cognizance has to be taken, that the sanction for prosecution has to be taken in ED case also, not just in predicate offense. Legally not correct to prosecute any government. That's what the Supreme Court said. Any government servant, be it an MLA or any employee, if the offense is done within the course of his employment. And that's how this sanction, that's how this order has come. To the extent that this, whatever framing of the charge or taking cognizance has not been set aside on merit. Only and only because the sanction is pending, this has been reverted back. The sanction has been squashed, the proceedings have been squashed. Only to the extent that sanction for prosecution has not been obtained. The judgment elaborately states that moment the sanction is granted, the case will be reverted back to the same place where it is closed, and we will be able to proceed with the case.